Guys, this is where it gets hectic. Does this mean that universities do not have the power to revoke their decisions to enroll and that the provisional acceptance clauses can only be effected by the courts? The lawyers out there, let us know what you guys think. Hello guys, how are you doing? You may or may not remember the case of Ntando Mnguni, the Masters in Information Technology student whose academic life was turned upside down 3 months before registration when the University of Limpopo deregistered her and fellow student Pelisiwe. The university invoked the provisional admission clause contained in its acceptance letters to revoke their registrations. This clause allows for the university to review admission on picking up any irregularity in a student's registration. In Ntando's case, together with Pelisiwe, the irregularity was having an undergraduate BTech degree from the Durban University of Technology instead of a traditional bachelor's degree. Ntando further obtained an honors in library and information science degree with an average of 60% from the University of KwaZulu Natal in Durban, which is the immediate requirement to enroll into the master's program, but that did not matter to the University of Limpopo. And now to the High Court case. First, setting out a factual synopsis, the judge in the High Court noted the following. On 16 August 2022, Ntando's supervisor 1, Dr. Monyela, informed her that she successfully concluded her dissertation and should be graduating in April 2023. Shortly thereafter, Dr. Monyela informed her that there were concerns about her Bachelor of Technology degree qualification. After various correspondence between Ntando and the university, she was served with a notice of termination of her studies on the 2nd of February 2023, which indicated that she failed to meet the admission requirements as stated in the general academic rules of the university. Ntando filed an internal appeal as provided for in the termination letter on the 28th of February 2023, but she received no response from the university. After several discussions between Ntando's attorney and the university, on the 23rd of May 2023, the university asked Ntando to re-register for a further academic year and repeat her master's program for a period of 12 months to give the university an opportunity to revisit its rules. Dissatisfied, Ntando approached the High Court arguing the university's decisions were unlawful, irrational, and unfair. She also argued that the university created a legitimate expectation and was restrained by the doctrine of functus officio. On the other hand, the university argued that it owed a duty to its students, past, present, and future, to ensure that its qualifications were of the highest standard. It also argued that the decision to terminate was not final, as she could have reapplied through the process of RPL recognition of prior learning. The court was called upon to decide on two issues. One, if the decision of the university to terminate Ntando's studies and the refusal to confer the degree on her must be reviewed and set aside. Number two, whether the court is in a position to substitute the university's decision with a decision to the effect that the degree must be conferred. The court considered two pieces of legislation, one, Section 33, 1 and 2 of the Constitution, that provide that everyone has the right to administrative action that is lawful, reasonable, and procedurally fair, and that everyone whose rights have been adversely affected by administrative action has the right to be given written reasons. 2, the Promotion of Administrative Justice Act 3 of 2000, PAJA, which gives effect to the constitutional right. On considering the facts and evidence, the court concluded the following. The university's decisions were procedurally unfair and unreasonable in that, number one, Ntando was merely informed that her studies were terminated without being given opportunity to address the university. 2, the failure of the university to attend to the internal appeal infringed on Ntando's right to fair administrative action that is lawful, reasonable, and procedurally fair. 3, the aim of the university's proposal to have Ntando enroll for a further 12 months was not clear as she had already completed her studies. Furthermore, the university's failure to adhere to the audi alteram partem principle, that is, hear the other side before making a decision, or the right to be heard, rendered the university's decision procedurally unfair as contemplated by PAJA. Furthermore, the university acted functus officio by revoking or reviewing its own decision to approve Ntando's enrollment in the first place. The same should have been done by a court of law. Guys, this is where it gets hectic. Does this mean that universities do not have the power to revoke their decisions to enroll, and that the provisional acceptance clauses can only be effected by the courts? The lawyers out there, let us know what you guys think. The court relied on the Constitutional Court in members of the Executive Council for Health, Eastern Cape, and another versus Kirkland Investments 2014, that an organ of state must apply for a court order to set aside any defective order it makes, so that the court can properly consider its effects on those subject to it. The decision remains effectual until properly set aside. The court ruled, 1, the decision of the university to terminate Ntando's studies and refuse to confer the degree on her was unlawful, therefore was set aside. 2, with regard to substituting the decision and conferring the degree, the court considered the doctrine of separation of powers. Also, the Constitutional Court that stated that substitution will only be permissible in exceptional circumstances as demanded by the principles of fairness. The university therefore had to consider the court's judgment and redetermine its decision. Furthermore, the university had to pay Ntando's legal costs in the matter. Guys, let me know what you think about this case. Is the university likely to appeal this decision, especially that part of the judgment that says it acted functus officio, which means that it had already done its part when it allowed it to enroll, which is what I understand from the judgment, and could not now revoke that decision. It needed to go to the courts to approve that. I mean, that will open a big can of worms, because the universities do that, right? They revoke, and are there offers of acceptance? They are, provisionally given. So it's not a complete offer at times. So it's going to be interesting what the courts have to say if this matter is appealed, or to just give more clarity with regards to that part. Guys, let me know what you think. If you like videos like this, hit that subscribe button and share this video with someone else. Cheers, bye-bye.